Hello friends, you are welcome in PVP video classes. I am Pankaj Kumar Tripathi going to present video number 6 and last video of the videos of group H on special suits. In this video we will discuss the provisions of Order 33 of the Civil Procedure Code 1908, in which the special rules regarding suit by indigent person, which are equally applicable defense in form of set off or counterclaim by defendant, have been provided. The reason behind providing such kind of provisions is that no person should be prevented to obtain justice because of his indigency, because he cannot afford the court fee. So if a person cannot pay court fee, then by special provisions provided in Order 33 in case of suit and provided in Order 44 in case of appeal, is permitted to file a suit under Order 33 or to file an application under or to file an appeal under Order 44 without paying court fee for such suit or such appeal. Okay? Here we will discuss only the provisions of Order 33. Primarily we have to know who is indigent, who is poor person for the purposes of Order 33. It is answered in Rule 1. It is very important in pre-examination, in mains examination, in interview, and for practical purposes also. Then you have to know the contents of application provided in Rule 2, through which person seeks grant to file a suit without paying fees as an indigent, and presentation of application. The contents of application have been laid down in Rule 2, and how the application would be presented, it has been laid down in Rule 3. These two are very important also. Then I have classified under a heading that court, how to decide the application. Court will decide how that whether the applicant is indigent or not. Okay? There are several means to decide it, provided in Rule 1A, Rule 4, Rule 6 and Rule 7. And the decisions shall be taken in the last sub-rule of Rule 7. Okay? Either application is rejected or admitted. If it is not rejected, if it is rejected, on what ground? The grounds have been provided in Rule 5. Okay? If it is not rejected, then even it is either admitted or the grant is refused. Either application is rejected on several grounds other than the ground of non-indigency, and the application might be refused on being non-indigent, and then effect of refusal has been provided in Rule 15, that he cannot file further suit on that being an indigent. Okay? It has been provided in Rule 15. Withdrawal of permission. Court may withdraw his permission what he has granted under the last rule of Rule 7, and through which under Rule 8 the application has been admitted. the permission may be withdrawn by court under Rule 9. Okay? And though the person is allowed to file a suit or to file a defense or to file an appeal without paying court fees, but it doesn't mean that it will be paid by government. No. The court fees shall be recovered. Recovery of court fee under Rule 14, either under Rule 10 or Rule 11 or Rule 11A or 12 or 13. So recovery of court fee, to know the provisions of recovery of court fee, one have to read the provisions laid down in Rule 10 to Rule 14. Okay? Rule 16 provides that the court fees is included in cost of suit. So it is paid by the person who is held liable by the court to pay cost of the case, the suit. Rule 9A has been inserted by the Amendment Act 1976, which provides a provision to provide free legal aid as per directive principles for state laid down in Article 39A, which has been inserted there, Part 4 of Constitution, by 42nd Amendment Act. Okay? And Rule 18 provides that central government may provide helps to the indigent person to take justice. So I have specified all the rules. Now I will not going to dictate each and every rule. I will dictate the important rules only, and if you need to read to know the provisions of other rules which will be not dictated by me, you should read it through barefoot. Now a case should be noted by you, that is Union Bank of India versus Khadar International Construction. Union Bank of India versus Khadar International Construction 2001 Supreme Court held that the word person in Order-33 includes juristic person also. It means legal person also, like corporation, etc. Okay? So even a company may claim to be an indigent. Okay? Now come on, who is indigent? It has been provided in Rule 1. It is very, very important. The meaning of indigent are the criteria to decide to be indigent for the purposes of Order 33. A person is indigent, it has been provided in Rule 1. I am reading Rule 1, that a person is an indigent person. There is nothing to be dictated here, just reading is sufficient. A person is an indigent person. It has been provided in explanation 1 of Rule 1. A person is an indigent person, A, if he is not possessed of sufficient means to enable him to pay the fee prescribed by law for the plaintiff in such suit. In bracket it has been written, other than property exempt from attachment in execution of a decree and the subject matter of the suit. There is a list of the properties which are exempted to be attached in execution of decree have been given in section 60 of the code. So you should write on the head of this phrase, other than the property exempt from attachment in execution of decree, section 60. Okay? Wherefrom you can know the properties which are exempted to be attached in execution of decree. You may know it from section 60. Okay? Now come on, or B, where no such fees is prescribed. Criteria of deciding of indigency, which has been provided in clause A of explanation 1, would be applied only when court fees is prescribed by law. If no fees is prescribed by law, then criteria provided in clause B will be applied. Sorry. Where no such fees is prescribed, if he is not entitled to property worth 1,000 rupees other than the property exempt from attachment in execution of a decree and the subject matter of the suit, except the property which are non-attachable and the property which is subject matter of suit, he doesn't have the property of value of more than 1,000 rupees, then the person is considered to be an indigent person. Explanation second is also important. Any property which is acquired by a person after presentation of application, if he acquires some property, it will be taken into account to decide his indigency as per the criteria provided in explanation 1 of rule 1. Okay? If any property is acquired by the person, the applicant, even after making the application, but without deciding that whether he is indigent or not, without deciding finally the application. Okay? Explanation third is also important. Where the plaintiff sues in a representative capacity, the question whether he is an indigent person shall be determined with reference to the means possessed by him in such capacity. In his representative capacity, what property is possessed by him? Only those properties shall be taken into account to decide that whether he is indigent or not. Not his person, not the properties which he holds in his other capacity. Okay? Now come on, contents of application. It is very important. Rule 2. Actually the application will be in form of plaint. Actually it will be a plaint. But making an application to be exempted to pay fee, being an indigent person. Okay? So the content, every application for permission to sue as an indigent person should contain the following particulars on the basis of Rule 2 of Order 33. 1. The particulars required in regard to plaints in suits, Order 6, Order 7. 2. A schedule of any movable or immovable property belonging to the applicant with the estimated value thereof, and signature and verification as provided in Order 6, Rule 16, Rule 14 and 15. Okay? So the application should be presented by the applicant to the court in person unless exempted by the court. Now I am reading presentation. So how it will be presented? So the application shall be presented to the court by the application in person unless he is exempted from appearing in the court, in which case the application may be presented by an authorized agent who can answer all material questions related to the application and who may be examined in the same manner as the party represented by him might have been examined had such property attended in person. Okay? It means the application generally should be presented by the applicant himself, but if he is exempted to be present in person, then it might be presented by his agent. Okay? Now come on, court how to decide the application. Okay? I am going to start from Rule 7. Under Rule 7, in last sub-rule, that is sub-rule 3, it has been provided that the court shall then either allow or refuse to allow the applicant to sue as an indigent person. last sub-rule, that is sub-rule 3 of Rule 7 of Order 33, the power has been given to the court to decide either to allow the applicant to file a suit as an indigent or to reject his application. And both orders, either to allow or to reject, shall be appealable under Order 43, Rule 1, Clause NA. Not the order of allowing, only rejecting orders. An order under Rule 5 or Rule 7 of Order 33 rejecting an application for permission to sue as an indigent person, okay, shall be appealable. So, if the application is rejected either under Rule 5 or under sub Rule 3 of Rule 7, it would be appealable under Rule 1, Clause NA of Order 43 as an appealable order. You should write down this point. Now come on, how to decide? In 1A, court has to inquire into the means of an indigent person. You should read it through direct. There's no need to dictate it, to be dictated. In Rule 4, examination of plaintiff, if court think fit, court may examine the applicant or his agent. Okay. In Rule 6, notice of death for receiving evidence of applicant's indigency. Okay. And notice must be given for 10 days to the adverse party, that's whether the applicant is actually indigent or not. Who will make the application objection against the claim of the applicant that he is an indigent person? It is the adverse party. So notice should be given to the other adverse party to make an objection, and to prove that the application is on false ground. Okay. So notice shall be given to the other party. And in Rule 7, procedure at hearing has been provided, and after hearing all the parties under sub Rule 3 of Rule 7, court shall have power to decide either to allow the applicant as indigent or to refuse to allow the applicant person to file the suit as an indigent person. Okay, it has been provided there. If he is refused, then what would be the effect has been provided in Rule 15. I am reading Rule 15. Okay, an order refusing to allow the applicant to sue as an indigent person shall be a bar to any subsequent application of the kind nature or the like nature by him in respect of the same right to sue, but the applicant shall be at liberty to institute a suit in ordinary manner in respect of such right. It means then he shall be barred to file next application to be allowed to file a suit as an indigent person, but he shall not be barred to file a suit in a general manner. It means by paying fees. Now come on, rejection of application. When application would be rejected, but before it I would like to dictate procedure. If application is admitted, it means if the applicant is allowed. Rule 8, where the application is granted, it shall be numbered and registered. Very important. It shall be numbered. The application, think the content of application having all the contents of a plant. So it is actually a plant. So then if it is admitted, that is numbered in Rule 8 and registered and shall be deemed the plaintiff in the suit. And the suit shall proceed in all other respects as the suit instituted in ordinary manner, except that the plaintiff shall not be liable to pay any court fees or fees payable for service of processes in respect of any petition, appointment of a pleader or other proceeding connected with the suit, except to pay the fees. All other manner will be ordinary. Okay, and the application shall be treated as a plaint, and it would be numbered and registered as a plaint under Rule 8. Now come on, the grounds when application might be rejected have been provided in Rule 5. There are several grounds. These are 7. The court shall reject. Rule 5 provides as the court shall reject an application for permission to sue as an indigent. The application which has been presented in Rule 3 shall be rejected. A. Where it is not framed and presented in the manner prescribed by Rule 2 and Rule 3. It means all the contents of plaint is not presented duly according to rules of Order 6 and 7. Okay? Or it is not presented as per the rule, as per the provisions provided in Rule 3. Then it may be rejected, it shall be rejected. Ground 2 is where the applicant is not an indigent person. If it is decided that the applicant person is not an indigent person, if it is not shown from his application that he is indigent person, if it appears on the basis of the list of property with their estimated value that the person is not an indigent person, then the application shall be rejected under clause B of Rule 5. C. Where he has within 2 months next before, it is very important, it has been asked several times in examination. Clause C of Rule 5, very important. Where he has within 2 months next before the presentation of the application disposed of any property fraudulently or in order to be able to apply for permission to sue as an indigent person. To make him indigent, he has disposed his property either fraudulently or only for with intention to make him indigent, to protect him from paying fees. Provided that no application shall be rejected if even after the value of the property disposed of by the applicant is taken into account, the applicant would be entitled to sue as an indigent person. Okay, but though he had disposed some property within 2 months before the making of application, if even taking into account of those property, if he would be able to be allowed as an indigent person, then the application shall not be rejected. It has been provided in the proviso of Rule 5 Clause C. Both are very important. Clause D, the ground D, where his allegations do not show a cause of action. It is a ground on which a plaint is rejected. E. Where he has entered into any agreement with reference to the subject matter of the proposed suit under which any other person has obtained an interest in such subject matter, then such person shall be liable to pay fee. Okay. And last point, the other point is where the allegations made by the applicant in the application show that the suit would be barred by any law for the time being in force. If suit is not maintainable, then how can the person be allowed to file the suit, even either as an indigent or otherwise? And the last ground is where any other person has entered into an agreement with him to finance the litigation, then the person, then it would be no matter that whether the applicant is indigent or not. The other person is able, he will pay the fee. Now, come on, withdrawal of permission. When permission shall be withdrawn, it has been provided in Rule 9. And don't think that there would be need of case law. No, there's no need of case laws. 9. The court may, on the application of the defendant, it means on the application of other party, or of the government pleader, of which 7 days clear notice in writing has been given to the plaintiff, order that the permission granted to the plaintiff to sue as an indigent person be withdrawn. Okay. It means permission of granting the application under Rule 8 or under Sub Rule 3 of Rule 7 may be withdrawn by the court after giving him 7 days prior notice to hear him, and after hearing him. When there are 3 grounds, on any of the 3 grounds. When first, if he is guilty of vexatious or improper conduct in the course of the suit. If he is guilty of vexatious or improper conduct in the course of the suit, or if it appears that his means are such that he ought not to continue to sue as an indigent person, he has obtained some other property, or C, if he has entered into any agreement with reference to the subject matter of the suit under which any other person has obtained any interest in such subject matter. So if he is misusing his capacity, the permission, or if he obtains property due to that his indigency has been seized, or he has entered into agreement with the person who can finish the case. On any of the 3 grounds, the permission which has been already granted shall be withdrawn. Okay. Now come on, recovery of court fee. Primarily, I would like to read Rule 14. Okay. Where an order is made under Rule 10, Rule 11 or Rule 11A, the court shall forthwith cause a copy of the decree or order to be forwarded to the collector, who may, without prejudice to any other mode of recovery, recover the amount of court fees specified therein from the person or property liable for the payment as if it were an area of land revenue. So how to be recovered? As recovery of area of land revenue. Okay. But on what ground it would be recovered and from whom? The grounds have been provided in Rule 10, Rule 11, Rule 11A, Rule 12, etc. Rule 10, very important. Cost where indigent person succeeds. Who will pay the cost? If indigent person succeeds the case. It has been provided here. Where the plaintiff succeeds in the suit, the court shall calculate the amount of court fees which would have been paid by the plaintiff if he had not been permitted to sue as an indigent person. The court fees would have been paid if he had not been permitted as indigent person. Such amount shall be recoverable by the state government from any party ordered by the decree to pay the same. Who will be ordered to pay the same? Who will be liable for cost of the suit? Okay? Who will be liable for cost of the suit? So you should read Rule 16, cost. The cost of an application for permission to sue as an indigent person and of an inquiry into indigency shall be cost in the suit. All things will be treated as cost in the suit. So according to provisions of Order 20A, the party who will be liable to pay the cost will be liable to pay the court fee and all other expenditure which have been paid by the state government for an indigent person, even when the case is succeeded, when the plaintiff succeeds. But there is a notable point, the last para of Rule 11, and underline it, and shall be a first charge on subject matter of the suit. Underline it. Okay. Rule 11, procedure when indigent person fails. If he succeeds, then 10. If he fails, then Rule 11. Where the plaintiff fails in the suit or the permission granted to him to sue as an indigent person have been withdrawn, either he fails or the permission has been withdrawn, or where the suit is withdrawn or dismissed, even suit is withdrawn or dismissed. A. because the summons for the defendant to appear and answer has not been served upon him in consequence of the failure for the plaintiff to pay the court fee or postal charges, if any, chargeable for such service, or to present copies of the plain reconciled statement, or B, because the plaintiff doesn't appear when the suit is called on for hearing. Under Order 9, the court shall order the plaintiff or any other person added as a co-plaintiff to the suit to pay the court fees which would have been paid by the plaintiff if he had not been permitted to sue as an indigent person. It means whether he fails in the suit or whether he withdraws the suit, or whether his suit is dismissed, he would be liable to pay the fees. Rule 11A. Procedure where indigent person suit abates. If suit is abated because of death of the indigent person, then who will pay the fee? It has been provided in Rule 11A. So if he succeeds, then what would be? If he fails, then what will be? If he dies, then what will be? Okay? Where the suit abates by reason of the death of the plaintiff or of any person added as a co-plaintiff, the court shall order that the amount of court fees which would have been paid by the plaintiff if he had not been permitted to sue as an indigent person shall be recoverable by the state government from the estate of the deceased plaintiff, which are in the hands of his successors after his death. The property would be liable to pay the fees. And state government may make an application either under Rule 10 when plaintiff succeeds, under Rule 11 when plaintiff fails, under Rule 11A when plaintiff dies, to the court to make an order for paying for recovery of the fees. Whenever an application is made, the state government shall be deemed to be a party. Okay, it has been provided in Rule 13. All matters arising between the state government and any party to the suit under Rule 10, Rule 11, Rule 11A or Rule 12 shall be deemed to be a question arising between the parties to the suit within the meaning of Section 47. Okay, it shall be deemed that it is a question to be decided by the execution court under Section 47. We will discuss Section 47 when we will discuss the execution of decree. Okay, so we have adequately discussed all the provisions. Now I have to discuss Rule 17. Okay, any defendant who desires to plead a set-off or counterclaim may be allowed to set up such claim as an indigent person, and the rules contained in this order shall so far as may be applied to him as if he were a plaintiff and his written statement were a plaintiff. So we have described all the provisions of Order 33, I think very well. If you have understand, then I am right. Okay, bye.